We have joining us this afternoon Professor Greg Wallace, Professor of Constitutional Law. He was telling me just a few moments ago off air that due to his expert timing, he actually was planning to talk about the issue of marriage in the law and the Supreme Court in his class today. It was all, he knew in advance. He just could sense when the decision would be coming down from the Supreme Court. I say that with tongue-in-cheek, and has been inundated with calls about participating in interviews, and I thank him for his graciousness with us this afternoon here on Viewpoints. And with that, Professor, good afternoon.
Good afternoon. Thanks for having me again.
Oh, it's our pleasure. So many questions to ask. What does this decision portend for North Carolina? Because if I'm not mistaken, North Carolina is in the 4th District, and the 4th District has made its decision. So does this mean that North Carolina can basically throw out the constitutional amendment that the voters passed in North Carolina some 6 years ago now, I think it is?
The decision today was to deny review. That means they are not going to hear the 3 sets of cases from the 4th Circuit, from the 7th Circuit, and from the 10th Circuit Courts of Appeals. Mm-hmm. And as you said, North Carolina is in the 4th Circuit Court of Appeals, in the 4th Circuit area, and is governed by the law that is issued by the 4th Circuit Court of Appeals. The 4th Circuit struck down Virginia's law that limited marriage to opposite-sex couples. And that was appealed then to the Supreme Court. They actually asked the Supreme Court, they file a petition for a writ of certiorari, which means that they asked the Supreme Court to hear the case. The Supreme Court today said no. And so that means, for all intents and purposes, that the case in the 4th Circuit is over with. And that the stay that was put in place from enforcing the court's decision is going to be dissolved. And as I understand it, they're already performing, or at least granting marriage license to same-sex couples in Virginia. Now, that has not happened in North Carolina, and it will not happen until one of the district courts in North Carolina, it's probably going to be the Middle District Court in Greensboro that is hearing the case that was pending the longest in North Carolina, challenging the North Carolina marriage amendment. It won't happen in North Carolina until one of those district courts issues a decision actually striking down the North Carolina marriage amendment. The district courts in North Carolina are bound by what the 4th Circuit has already decided. And so they really don't have any real room for discretion here, and I don't think there's any argument to be made that the situation in North Carolina is sufficiently different from the situation in Virginia. Both states had constitutional amendments banning same-sex marriage. That you might get a different decision in North Carolina that you would in Virginia. So once that happens, which as I understand it, the ACLU is going to ask tomorrow to file for an injunction, a decision in that case. And once the decision is made in the North Carolina case, then that's going to open the door for same-sex marriage in North Carolina.
In spite of the fact that the voters in North Carolina passed a constitutional amendment that basically is saying that amendment is contrary to federal law, right?
It's saying that the 4th Circuit has held that it violates the gay couple's fundamental right to marry, fundamental right to be married to one another. And because it does so, then it cannot stand. And they base that again on a recognition of a fundamental constitutional right. Even though that right's not written in the Constitution, it's a right that is fundamental, which means it is just as important and just as applicable as those rights that are written in the Constitution, such as the right to free speech. So, but this is a fundamental right to marry, and that's what the Fourth Circuit has recognized that gay persons have, and therefore any conflicting state law is unconstitutional.
This is decided related to those three cases. This begs the question, will there be other cases that the Supreme Court could take up in the future if the Supreme Court so chooses? And I want to get to the justification for the Supreme Court, if you will, passing on this. So by default, they've approved the appeals court's decisions. Am I correct on that?
Yes.
All right.
So what that is going to mean is that the three circuits there, the Fourth Circuit involved Virginia, the Seventh Circuit involved Indiana and Wisconsin, and the Tenth Circuit had cases from Utah and Oklahoma. But those three circuits actually include additional states as well. And so as far as in each circuit, the law of the circuit is that same-sex marriage is a fundamental right. So this will affect not only same-sex marriage in the states that I just mentioned, but also in Colorado, Wyoming, Kansas, West Virginia, North Carolina, South Carolina.
All right. Now, do you have other challenges that are underway in other circuits?
Yes, there are. There are two circuits, the Sixth Circuit and the Ninth Circuit, in which cases have been filed appealing from lower court decisions, and those lower court decisions have been, with the exception of one lower court in Louisiana, the lower court decisions have been unanimous in favor of recognizing a constitutional right for gay persons to marry. Those two circuits, the Sixth Circuit and the Ninth Circuit, have already held arguments in the case, and so we're just awaiting a decision in those two cases. Then there are two other cases, in the Fifth Circuit and in the 11th Circuit. The Fifth Circuit is going to take up the case from Louisiana as well as a case from Texas, and then the 11th Circuit is taking up a case from Florida. In which those cases have not yet gotten as far as having arguments in the case, and so they will be decided later. The next two decisions we ought to have is from the Sixth and the Ninth Circuits, and then after that from the Fifth and the 11th. So any of those four circuits, the Supreme Court could decide to hear the decision, to review the decisions of one or both or more of those circuits.
I want to get to the reason given, possibly if there was a reason given by the Supreme Court today as to why they did not hear this case. If any of these other cases, the 6th, the 9th, the 5th, or the 11th, is decided in favor of defending state constitutions in their various districts, if one is in favor of a action to prevent same-sex marriage, does that then force the Supreme Court to take up the issue, or could they let stand a Fifth Circuit case that would be contrary to all the other decisions?
I think that if you wind up with a split in the circuits, that is when the Supreme Court would almost have to move in and take one of the cases and decide the whole matter for everybody. And I think that's one of the reasons why they did not decide to review any of the cases today, is because as of right now there is no split in the circuits. Now there was a 2004 Eighth Circuit decision upholding a gay marriage, a marriage amendment in Nebraska that prohibited gay marriage, but that's sort of an outlier, and then people generally don't think that really creates a split in the circuits because it's older, and but as far as the decisions that have been rendered post Windsor, the Windsor decision in the DOMA case last summer, I guess a year ago last summer, as far as the decisions that have happened since that time, all the circuits have been in agreement so far, and I guess it's conceivable that the Supreme Court could never decide to hear a case involving gay marriage. If all of the circuits decide that are in agreement that gay marriage is a constitutional right, then there is no real reason for the Supreme Court to take up the issue. So that's a possibility. I think it's unlikely because I think you may have maybe either the Fifth or the Sixth Circuits weighing in the other direction.
What is the procedure for the Supreme Court to decide whether or not they will take up a case? In other words, is there a vote of the justices? What do they do to say we will take up this case? And does it require, for example, a majority, that sort of thing? What is the rule, the procedure?
It's called the Rule of Four. Now, there are 9 justices on the Supreme Court. Under the Rule of Four, it takes only 4 justices to commit the court to reviewing a case. So what we're seeing today is that there was less than 4 justices on the court who wanted to hear one of these circuits cases dealing with gay marriage today. So now, if you read the past decision, the decision in Windsor, which is the Supreme Court's really latest decision weighing in on the gay marriage issue, you had the 4 liberal justices on the Supreme Court plus Justice Kennedy. That gave you the 5-justice majority voting to strike down the Defense of Marriage Act, the Federal Defense of Marriage Act. And so you've got 5 justices up there that would probably be ready to rule that gay marriage is a constitutional right, and that would impose a 50-state solution, so to speak. Right. But the 4 dissenting justices apparently don't want to hear the case now, and none of the 4 justices that voted in the majority, you don't have a 4 justices in among the majority that voted to hear it either. So it takes 4 justices. They don't have that right now.
Okay, and I want to get back to the possible defense of this issue in a few moments if there are some alternative arguments or arguments yet to be discussed. But I'm going to ask you if you can stay with me. I first want to get Chris from Havelock on the line with us. Chris, your question, sir.
How are you guys doing tonight?
Very well. Yes, sir.
When in North Carolina a couple years back we had the vote to either make the Constitution say marriage was between a man and a woman or not. Now, personally, I voted for it not to be. I do go to church. I am a Christian. My belief was more, I'm not going to judge these people. Okay. They want the same tax rights, whatever their reasoning is. I do feel, though, that if they shouldn't force pastors or people who don't believe this because of their religious beliefs to be able to do that, say make them go to the justice of the peace, but isn't it the justice's job to hear cases? I mean, your guest just said that they didn't have enough justices, but why aren't they doing their job?
They are doing their job. They are not required under the Constitution or on the rules that govern the Supreme Court to hear any particular case. All of the cases are reviewed at the Supreme Court, for the most part, under what's called discretionary review. So the timing of these kinds of decisions is very important to the court. They oftentimes will want to let issues sort of percolate in the lower courts before they come in and weigh in themselves, and that's because as they percolate in the lower courts, the issues get more clearly defined, and more lower courts have an opportunity to weigh in and to make decisions and to offer different rationales for their decisions. And the courts feels like, I think the justices generally feel like that it's better to have more courts look at this than less. And so that's why they're sometimes hesitant to jump in early on in something like this.
I understand where you're coming from, Chris, and you bring up a very interesting question I want to ask of our guest. With this decision of the Supreme Court not to take up the appellate court cases, thereby by default letting them stand, what impact does this have on churches and institutions that have strong feelings and announced feelings associated with heterosexual versus homosexual marriages?
Well, I think from a church's standpoint, you're not going to see the government forcing churches to hold gay weddings, okay? But I think what you might see, and again, this depends a lot on how far the advocates of gay marriage push things, and some of them have been known to try to push things very far. But I think you could see down the line the state saying to a minister, if you don't perform gay weddings, then you cannot perform heterosexual weddings. We won't license you to perform heterosexual weddings if you will not perform homosexual weddings. And so I could see the state, doing something like that. And I think churches have got to take a long and hard look now, once gay marriage becomes widespread, at whether they ought to continue to participate in wedding services in which they're functioning as agents of the state in declaring people married for civil purposes. I certainly think that churches can develop their own notion of religious weddings, that are performed in the church, and they can set their own rules for those. But whether they are going to want to continue to also as well, right now when a pastor performs a wedding, he's acting both as an agent of the church and as an agent of the state. Mm-hmm. And so it may be in the future that pastors are no longer going to be able to act as agents of the state. Now, as far as non-religious or non-ministerial folks, the photographer who's asked to take pictures at a gay wedding, or the baker who's asked to bake a cake, if those people have religious convictions against gay marriage and they do not want to participate in something that actually facilitates gay marriage, and we're not talking about as the gay advocates portrayed the situation in Arizona several months ago, that Christians want to be able to deny gays service in a restaurant or things like that. We're not talking about that. We're talking about when they're asked to do something that actually facilitates a gay wedding. There ought to be, in my view, laws that protect those people and protect their religious freedom. Unfortunately, we don't have any of those laws yet in North Carolina. There was a law that was proposed not in this current legislative session, but one last year that was blocked at the last minute. But I think we've got to get behind those kinds of laws that, in a very modest way, primarily dealing with small businesses, where the owner of the business is likely to be the one carrying out the providing the services of the business, that person ought to be free from being fined under anti-discrimination laws if they don't facilitate gay weddings.
Is that a law that could be added to the legislative action, or does that require a constitutional action on the part of the voters?
I think that just requires a statute, okay. And many of the states have these state sort of religious freedom laws, and I think North Carolina needs one, and I think it ought to, I think it ought to narrowly address these kinds of situations, and I think that's one thing. If people want to know how to appeal to their legislators, that's something they can appeal for. Some statutory protections for religious freedom for those who are who may be forced to facilitate gay weddings, when doing so would violate their religious conscience.
Our guest, and thank you for taking the time to be with us, Professor Greg Wallace. Professor, very quickly, have we seen any new arguments presented, the outstanding cases that might in fact provide an alternative decision, might be enough to sway the justices in their decisions?
Well, one other thing that I find very interesting here is that Justice Kennedy rested his argument against DOMA on this idea of animus, that people that passed the Defense of Marriage Act were acting out of a bare desire to harm people.
Right.
That argument has not been popular in the lower courts. The lower courts instead, for the most part, have recognized a fundamental right to marry, which is a very different argument and one that I'm not sure Justice Kennedy would embrace.
I want to thank our guest this afternoon, Professor Greg Wallace, Professor of Constitutional Law at Campbell University School of Law. You're listening to Viewpoints here on the Talk Station FM 107 AM 1240.